Uh, in today's lecture, we are going to talk about neutrality, like what is the meaning of neutrality and what basically how this particular concept has developed under international law. After that, what are the rights and duties of a neutral state, that if any state is called as a neutral state, and if any state has adopted an attitude of neutrality, what are the rights and duties of that particular neutral state, and all the related concepts which are very very important. Another important thing which we need to cover under this particular topic is a very important case law relating to this particular topic. The name of the case is Alabama arbitration, and that is a very very important case which we need to cover. Now, talking about neutrality, basically the meaning of neutrality. See, neutrality, it is a status which is acquired by those states which do not participate in a war. So whenever you try to understand the basic meaning of neutrality, the one thing which you need to always remember is that it is a status, more precisely an attitude of impartiality which is acquired by those states who are not participating in a war. So it is basically, you have to remember, an attitude of impartiality, which means that the states, they have decided to be neutral, which means whoever are the participants of war, they are not going to coordinate or help or oppose those people. They have just adopted an attitude which is a neutral attitude, which is an impartial attitude. Now, going ahead with this, Oppenheim has given a definition of neutrality, which states that neutrality as the attitude of impartiality adopted by third states towards the belligerents and recognized by belligerents, such attitude creating rights and duties between the impartial states and the belligerents. So basically, Oppenheim has given us a threefold definition. There are three important elements under his definition. The first thing he is saying that it is an attitude of impartiality, and it is adopted by third states, which means the states who are not the participants of a war. Now, states adopting such an attitude do not participate in a war and are known as a neutral state. Now, neutrality therefore discourages war, and if war takes place, it serves to localize war and regularizes international relations. So basically, it is the first thing which we need to understand according to Oppenheim's definition is that it is basically an attitude of impartiality, and this attitude is adopted by third states towards the belligerents, and this attitude also needs to be recognized by the belligerent. Now, if you are a neutral state, which means you being a neutral state, you are discouraging the war, you are not promoting the war. Like for instance, you may say that if there are two countries who are indulged in a war, so both the countries are A and B. Now, A needs support of C and D as well in order to go ahead with the war. So if C and D decline to support it and they adopt the attitude of neutrality, then in that context, C and D are discouraging war, because A cannot go ahead with the war without the help and support of C and D. So basically, this is very important thing, that if you are a neutral state, you are discouraging the war, and even if the war takes place after your discouragement, you are serving to localize war and regularize international relations, which means that the countries who are involved in war, they will be only the affected nations and no other nation will be affected. The countries who are neutral, they can continue to work, they can continue to maintain their international relations, international trade, and so on. There will be no effect on the neutral states. Now, whenever a state wishes to remain neutral, it is desirable that it makes an immediate notification of neutrality. Now, this thing is very very important, that whenever a state has decided that under this particular war we are not going to supplement or support any XYZ country, so it is always desirable that they make an immediate notification of neutrality. So it has been regarded as a necessary by most of the states. Now, neutrality of the state, it commences with a notification. Now, during the time of Second World War, at that point of time, immediately after its outbreak in September 1939, almost all the neutral states, they announced their neutrality at once and specifically communicated this particular fact to the belligerent groups. So basically, this thing is very very important, that if you have adopted an attitude of neutrality, you need to make an immediate notification with that particular regard, and it was seen as an example during the outbreak of Second World War. Most of the countries, they announced their neutrality at once and specifically communicated this particular fact to the belligerents. Now, second important element according to the Oppenheim's definition is that the attitude of neutrality needs to be recognized by the belligerents. Now, what is the meaning of this? This means that if you have declared, if you have come up with a notification that now we are a neutral state, so this particular attitude necessarily needs to be recognized by the belligerent nations, the nations which are indulged in war. Why is that so? Because at the time of World War One, there were n number of instances where it was seen that the countries were forced into the wars. Even if they adopted the attitude of neutrality, they were forced into the wars. Their neutrality, their adoption of neutrality was breached, and they were forced to come and join the war. So basically, to avoid such circumstances, the attitude of neutrality, it needs to be recognized by the belligerent groups as well. So the first thing is that you will declare that you are neutral, and the second thing is that the declaration by the belligerents that yes, we are recognizing their attitude of neutrality, and we are adopting a policy of non-interference in their governance, and we are not going to ask for any aid and advice, and neither we are going to breach their neutrality. So this particular thing is also very, very important. And the third one is, whenever recognized, they create certain rights and duties against each other under international law. Now, once the belligerents recognize the neutral attitude of a third state, they create rights and duties against each other under international law, and they have to abide by such rights and duties by following the principle of neutrality. Now, is the meaning of neutrality clear? Is going ahead, we have to talk about development of neutrality. Now, how this particular criteria has developed over the years. See, the fact of neutrality is as old as the war itself. Its antiquity, the notion of neutrality as a legal institution, it was not well established, mainly because belligerents did not recognize the attitude of impartiality adopted by states. I told you that at the time of World War One, and even after that, there were a number of instances. Under which it was seen that the belligerent groups, they breached the attitude of neutrality of the third states. So basically, the concept is old, but it was not much developed at during the ancient times. Now, in the Middle Ages, a number of bilateral treaties were concluded by the states, stipulating that neither party to the treaty assist the enemies of the other in any way during the time of war. Now, conclusion of many such treaties gave rise to the gradual development of institution of neutrality in international law. Now, these were instances after the by the end of 17th century, neutrality began to be recognized as an institution, but it still was infancy. Now, neutral states as well as the belligerent boards very frequently violated their duties towards each other, but the concept of neutrality, it developed during the 18th century, especially in the later half, in the sense that the belligerents gave due regards to the neutral and their territory. Now, whenever neutral territory was violated by the belligerents, reparation was asked for and was given by the belligerents. Now, what do we notice over here is, you need to understand and follow this hierarchy. Here under the development, we are talking that the concept is very old, but we have seen a number of instances which where the concept has been breached. Now, by the end of 17th century, neutrality began to be recognized as an institution, but it was still infancy. Now, by the basically, this particular concept has developed during the 18th century, especially in the later half of the 18th century. Now, why? Because at that point of time, it was noticed that the belligerents, they started giving due regard to the neutral states and their territory. Now, whenever the neutral territory it was violated by belligerents, reparation was asked and was given by the belligerents. So basically, the principle of reparation came into the picture at this point of time during the later half of the 18th century, that if you are not recognizing the rights and duties of a neutral state, and you are simultaneously breaching it, so for that matter, whatever damage has been done by you, you need to restore it by the way of reparation. So this particular thing also became very, very important at that point of time. Now, talking about the development, there were some examples which gave to the rise, which gave rise to the concept of neutrality. So in 19th century, finally the concept of neutrality developed extensively because of many reasons. So what were the reasons? There were basically four reasons. The first one was United States remained neutral from 1793 to 1818 in the Napoleonic Wars. So this was a very good example to maintain this particular concept and attitude of neutrality. The second one was Switzerland and Belgium. They declared their permanent neutralization. Now, do not get confused. Neutrality can, whenever we are talking about neutrality, that is not permanent in nature. But when you come across the term neutralization, it means that the country has permanently adopted this attitude of neutrality. This is permanent in nature. So whenever you come across the term neutralization, it means that the country has permanently adopted the attitude of neutrality, and it is not the member of UN. So basically, Switzerland and Belgium, they have adopted their permanent neutralization. So this also gave a very good example to adopt the neutral attitude. The third one is that rule of free ship, free goods was formulated by the Declaration of Paris in on April 16, 1856, which provided that the neutral goods not contraband of war shipped on an enemy vehicle should not be appropriated. And the fourth and the most important example was the arbitral pronouncement recognized the rights and duties of the neutral. So the case which I was talking about is Alabama claims of arbitration in the year 1872. It was the most important amongst them, where Britain was a neutral in, see, there was an American Civil War, most prominently between North America and South America. So at that point of time, Britain, it gave us, it adopted the attitude of neutrality, it adopted the attitude of impartiality, and Britain said that I am not going to supplement even North America or South America. I am going to stay neutral. Neither I am aiding them in the into the war, neither I am obstructing them into the war. I am going to stay neutral. But what Britain further did, that it started giving basically supplements to your North America. So the South America, it started protesting against this particular incident, that Britain is supplementing, it is destroying the this particular concept of neutrality. Whatever it has adopted, it is destroying the same. So under this particular case, this particular thing was referred to the to arbitration, and there was basically, that is why it is named as Alabama claims of arbitration of 1872. And that at that point of time, by the principle of reparation, Britain was required to pay a very huge amount in gold to America as a compensation for the violation of law of neutrality. So all these four instances, they played a very important and very major role in the development of your this concept of neutrality. So the first one was the attitude of US in Napoleonic Wars. The second one was Switzerland and Belgium, their declaration of permanent neutralization. The third one was the rule of free ship, free goods, which is not very important. And the fourth one is very important and very crucial, the Alabama claims arbitration of 1872, where Britain adopted neutrality and hence breached neutrality in the American Civil War of 1862, and as a result of which it was required to pay a huge sum in gold to America as a compensation for the violation of law of neutrality. So all these four instances, after witnessing this, we can say that neutrality was evolved as a very developed concept under the international law. Now, talking about neutrality under the Covenant of League of Nations and neutrality under your United Nations. Now, basically, see, you both United Nations and League of Nations, they tried to suppress the concept of neutrality somehow. Let's see how. So basically, under the League of Nations, basically it is said that it affected the notion of neutrality. Now, neutrality, under the League of Nations, there were two kinds of wars which were defined. The first was those which were restored to not in disregard of the provisions of the covenant, that is, those which were not forbidden. See, under the not forbidden wars, what is the meaning of not forbidden wars? The wars who are not in disregard to the provision of League of Nations, which means that these kinds of war are going with respect to the provisions which have been incorporated under the League of Nations. So if they are not in disregard of the provisions of League of Nations, they are legal wars. And if they are legal wars, under this particular instance, the countries were allowed that they can adopt the attitude of neutrality. So for example, if two countries are indulged into armed conflict, and it is obviously mentioned under the Charter of League of Nations, under the Covenant of League of Nations, that these kinds of armed conflicts are permitted, and both the states who are indulge into the war, they can reciprocate until and unless League of Nations comes up with a decision to secure peace and security. Now under this, but if this is an example, so under this kind of armed conflict, the other states, the other countries, they have the right to maintain their neutral attitude. Why? Because these wars are not forbidden, they are not in disregard with the provisions of the covenant. The next kind of war which is mentioned under your League of Nations, which was mentioned under your League of Nations, was forbidden wars, which means that they are forbidden. Why? Because they are not in accordance with the provisions of the covenant. So basically these wars are illegal wars, and if any country is indulging into an illegal war which is not permitted according to the league, so for that matter, what will happen, that the other countries will not be allowed to adapt the attitude of neutrality. And if the other countries are not allowed to adapt the attitude of neutrality, under that particular concept, they have to support, aid and advise the aid and advise the League of Nations in that particular war. They are not allowed to adopt the attitude of impartiality or neutrality, which means this is a kind of suppression of the concept of neutrality. So in case of not forbidden wars which are not in disregard of the provisions, countries can adopt neutrality. But if in case of forbidden wars the countries cannot adopt neutrality, they have to indulge, they have to involve them into the wars. And by this particular provision, it was interpreted that the League of Nations, it considerably affected the notion of neutrality. Now talking about neutrality under the United Nations. Now see, under the Charter of as we discussed under the Covenant of League, so similarly under the Charter of United Nations, the provisions of collective security and responsibility were again made, but it was stronger than the League, because all the smaller powers were ready to surrender their freedom of action to the great powers. Now Security Council, we know that it has been given the real powers and has been given competence for the application of sanction against a state. Now its decisions are legally binding on all the members of UN. So Article 2 subclause 5, it provides that the members shall give to the United Nations every assistance in any action it takes in accordance with the present charter. So if the Security Council is taking any action and none of the none of the 5 permanent members are going to use their veto, so in under that particular context, each and every country has to give assistance in any action which is adopted by Security Council. So it is also a kind of suppression of your concept of neutrality. So according to the above provision, it was clearly led that many publicists concluded that neutrality has now come to an end as a legal institution. So no member of the UN can ignore or resist the call of Security Council on the ground that it wishes to pursue a policy of neutrality or has by a treaty pledged neutrality to state against which sanctions are applied. Is this both this neutrality under your league and neutrality under UN clear? Is there any confusion?
No, ma'am.
It was mostly presumed that both these things, as in a prominent organization, they as in prominent international organization, they uh, somehow this particular suppress the concept of neutrality. Now talking about under which of the following cases it is still possible for a state to adopt the attitude of neutrality. So the first one is incompetency of Security Council. This is very very general. When will the Security Council be incompetent? We know that it has been granted the power to maintain international peace and security. Now obviously we know that it has been given the powers to take appropriate measures against breach of peace, threat to peace, act of aggression. So basically if security council is taking steps against any of under any of this particular head, and any country exercises its veto power, any of the permanent members, they exercise their veto power, so basically that particular resolution will be immediately cancelled, and as a result of which the other states will be permitted to adapt the attitude of neutrality, because now we have studied that security council can impose any decision on its members when, because under the situation when there is a breach of peace, threat to peace, or an act of aggression. So basically under these particular instances, if it is passing a resolution, so that particular resolution will be binding. But what if it is not passed by the virtue of the fact that any permanent member of UN has specifically utilized its veto power? So basically that resolution will not be adopted, it will be failed simultaneously, and under this particular situation, other states will be permitted to adopt the attitude of neutrality. So incompetency of security council is the first thing. Next one is self defense. See, the right of self defense, it can be exercised by the state only when the armed attack occurs against it in accordance with article 51 of the charter. Now self defense, obviously if there is an attack on a state, so the right of self defense has been given under UN charter with under the article 51. So basically if whenever the another state is reciprocating by using its power of self defense, if in that particular situation, for suppose A and B, these are two countries. Now A has attacked B, and B, by exercising its right of self defense, has simultaneously attacked on A. So what will be the status of the other states, the third state? So obviously whenever there is a question of self defense, the other states, they can adopt the attitude of neutrality until and unless security council comes up with a prominent decision in this particular aspect. So under this particular situation also, the countries can adopt the attitude of neutrality. The third one is domestic jurisdiction. See, Article 2 and Para 7 of the Charter, it specifically lays down that the United Nations shall not intervene in those matters which are within the domestic jurisdiction of any state. So obviously, if there is an internal disturbance, insurgency in a state, obviously UN has no jurisdiction. But even if Security Council feels that it needs to take action, so because it considered it's necessary to control the threat of peace, breach of peace, and act of aggression, it can take an action. But if there is nothing like that, UN will not intervene in your domestic matters, and as a result of which, if there is a domestic disturbance, internal disturbance, basically insurgency in your country, so for that matter UN is not going to intervene. And what will be the attitude of the other states? They will stay neutral. See, when I was teaching you insurgency and belligerency in class, I told you that under these two concepts, one thing is very, very essential: the attitude of neutrality. So that is the only thing which we are talking about here in detail, which means that there is no participation within your domestic jurisdiction by United Nations. And if United Nations is not permitted to intervene in your domestic matters, obviously it is not going to intervene in the same. So if there is a situation, if there is a domestic disturbance in your country, what should be the attitude of the third state? So the attitude of the third states will remain neutral. So these three things, these are very, very important. Your first one was incompetency, the second one is self defense, and the third one is domestic jurisdiction. The fourth one is unwillingness to participate in an armed conflict. Now what is the meaning of this particular thing? See, if a security council determines under article 39 that there exists either a threat to peace, breach of peace, or act of aggression, and thereby it further decides that action under article 42 shall be taken against the culprit state, in such a case council has to decide that whether action shall be taken by all the members or by some of them. So if there the action Security Council decides that if the action needs to be taken by some of the members, so basically the remaining states, they will be unwilling to participate in the armed conflict, and as a result of which they are going to stay neutral. So under these circumstances, countries are allowed to stay neutral. They're allowed to adopt the attitude of impartiality. Now, if you are enemy to the signatory of the charter, according to article 107 of the charter, it authorizes the member of UN to take any action against an enemy of any signatory to the present charter and the non-members of UN. Basically, if you are a non-member, like I gave you the example of Switzerland, which has adopted the attitude of neutralization, so it is permanently neutral. So for that matter, if you are a non-member of UN, you are obviously allowed to remain neutral. Security Council cannot intervene in your matters because you have adopted neutralization. Now, talking about rights and duties of a neutral state, the third point of the definition of Oppenheim, what are the rights and duties of a neutral state? Now, duties of a neutral state, see, the first one is abstention. We know the meaning to which means that you have to refrain from doing something. So basically, a neutral state is required to adopt the attitude of impartiality towards all the belligerents. They are not going to provide any assistance directly or indirectly to any of the belligerents. Now, it has also been mentioned under your Hague Convention, which deals with neutrality in land and sea warfare respectively, and it is laid down under this that the belligerents, you are not going to give any facility directly to the belligerents concerning military or naval operations, and it will be regarded as illegal. So basically, the abstention is a duty of a neutral state. It does not needs to give any assistance directly or indirectly to any of the belligerents. The next one is prevention. Now, what is the meaning of prevention? See, article 3 of your Hague Convention, it is telling the belligerents to install on the neutral territory any wireless station or any apparatus intended to serve as a means of communication with belligerent forces, or to make use for a purpose exclusively military, or installation of this character. So there are n number of activities which have been mentioned under the Hague Convention, and which is forbidden, that the belligerents cannot do these things. So what will be the duty of a neutral state under this particular head? The duty will be to see that the above activities are not carried on by the belligerents on its territory. So this particular thing is also very, very important. Duty of a neutral state. The first one is abstention, the second one is prevention, the third one is acquiescence. Now, talking about acquiescence, what is the meaning of acquiescence? See, basically it is acquiescence is a correlative to belligerents privileges. Now, if there is a neutral state, it has sustained incidental damages by exercising their legitimate rights of the belligerents. So in that particular situation, it must give acquiescence to it. For example, if the belligerents have a right to visit and search and capture a sea, and while exercising their right to visit of search and capturing the sea, they have damaged, they have caused any xyz damage to the neutral state, so they must restore that particular damage. This is the meaning of acquiescence. Now, the next one is compensation or restoration, which is very, very obviously very, very clear that a neutral state, it is under a duty not to allow either the belligerents to do any activity on their territory which is forbidden. Even if they indulge into the forbidden activity, they have to compensate for the same, and they have to restore the same. So basically, this compensation and restoration is also very, very important. And the last one is your reparation, which was discussed under the Alabama claim, as I told you. Now, under reparation, obviously you have to restore whatever damage has been done by you. So this particular thing, all these things are the duties of a neutral state: your abstention, prevention, acquiescence, compensation, and reparation. Now, talking about rights of the neutral state. Now, what are the rights of a neutral state? Inviolability. What is the meaning of inviolability? See, most important rights of a neutral state is inviolability of its territory. So which means that warlike acts, or to say hostile acts, it cannot be committed by either of the belligerents within the territory of the neutral state. Correspondingly, it is the duty of a belligerent state not to commit any warlike activity on the territory of a neutral state. So basically, this is a corresponding duty of your of the neutral state and also of the belligerent states. Trade with the other countries. Now obviously if you are a neutral state, you have been given the right to trade with the other countries because you're a neutral state, and the other neutral states are also free. So if they are not indulged in any war, any activities, they are not aiding and advising in any aspect relating to war, they are free, and you are free to trade with the other countries. The next one is very very important: neutral persons and property under belligerent jurisdiction. What is the meaning of this particular head, neutral persons and property? See, there might be n number of people belonging to the neutral state who have been somehow, who are living under the belligerent state. So basically, if the belligerent state is involved in any warlike activity, it is the duty, or it is their duty basically to protect those subjects of the neutral state, which means that the neutral state has a right to see that its subjects residing in the territory of belligerents are not given ill treatment. So whoever are the subjects of a neutral states, they have to be protected by the belligerents, and it is a right of the neutral state to see that the subjects residing in the territory of belligerents, they are not given ill treatment, and further its property lying in the territory of the belligerents are not seized and destroyed. Now, this right gives a duty to the belligerents to provide the nationals of the neutral state fair treatment and not to capture the property of a neutral state unless necessity so demanded. So basically, this is also a very, very important right of a neutral state, that they need to protect the neutral persons and property who are under the belligerent jurisdiction. The next one is right to grant asylum. Now, what is this? What is right to grant asylum? See, the neutral state, it has a right to grant asylum to any person, including those who are the members of the belligerent armed forces. So the asylum granted by the neutral state is sometimes called neutral asylum. So basically, neutral states, they have a right to grant asylum to any person, including those who are the members of the belligerent armed forces as well. They can give a temporary asylum to them, and this kind of asylum is named as a neutral asylum. The next one is compensation and restoration, which we discussed in the previous slides as well, that the belligerents whose forces have, in contempt of law, violated neutral territory, they are bound on the principle to make reparation for the wrong done to the sovereign thereof. So that wrong is essentially a public one, and reparation manifests an appropriate expression of national regret that the sovereign was treated with indignity. So the neutral state has a right to demand complete restoration of any person or any property. So these five rights of a neutral state, they are very very important: inviolability, trade with other countries, neutral persons and property under the belligerent jurisdiction, right to grant asylum, and compensation and restoration. Is there any confusion in any rights or any duties of a neutral state? Because this will obviously be asked. This is a very very important thing, and this entire law, it is mostly based upon your definition of Oppenheim. It has been emerged by the definition of Oppenheim extensively. So is there any confusion regarding any of the topics which we have covered today? Anyone? All right then. So basically this was all about neutrality. We need to understand, what you need to remember over here is that what basically is this concept, how this particular concept has developed over the years, and how neutrality under the covenant of League of Nations and neutrality under United Nations were somehow are somehow suppressed. But again, what are the conditions under which states are still permitted to adopt the attitude of neutrality? And apart from this, what you always need to remember is the rights and duties of the neutral state. So basically, there are five duties of a neutral state and five rights of the neutral states, which you need to remember always. And apart from that, the case which we discussed is a very simple and easy case. The Alabama arbitration, that whatever the disturbance that took place during the American Civil War, and UK adopted the attitude of neutrality, but somehow it breached its attitude of neutrality, and as a result of which it was forced to pay heavy compensation by the principle of reparation. So this case is very very important that you need to understand. And apart from this, these are the concepts which you need to understand. Thank you very much. Now, in the next lecture, we are going to discuss your cases, important cases relating to second module and your recognition of states. So that particular class will take place on Saturday, as I have already notified. Is there any confusion? So please ask it now.